This lesson is about pleadings, so I will very cursorily, very briefly take you through the civil process so that you understand the context of pleadings. This is not meant to be a lesson on the civil process. You can kind of think of the process as beginning with the suit. Then you identify and frame the issues, which means the points that are in dispute between the parties. And after the evidence and arguments, you have the judgment. Now, in this long judgment, there's the operative part, which tells you as to who has won and who has lost. That is the decree. And the person who's won is called the decree holder. The one who's lost is called the judgment debtor. And of course, then once the decree has been made, then you can either go for the execution of the decree, which means that you try to get this implemented, or if there's any opposition to this decree, one could go in appeal. This very briefly are the stages of the civil process. Like I said, this is not detailed, but it gives you a brief idea. Let me detail this now a little further. Now, when you're talking about a civil suit, you're talking about disputes that are of civil nature. Now, to know what disputes of civil nature are, you can have a look at section 9 of the CPC. But let's think of it like this. You have the court, and I'm representing it by this diagram. So you have the court, and the two parties that you have are the plaintiff and the defendant. So these are the two parties. I've just highlighted it and marked it for you as P and D. So there's the institution of the suit. Then you identify as to what the disputed points between these two people are. You find the issues. Then you have the evidences that are led by these parties. You have the arguments. Then there's the judgment. The operative part of the judgment is the decree. And then of course it's followed by the stage of execution or appeal. So with this, we are pretty clear with the broad outline of the civil process. So now let us talk about the pleadings. Now when I talk about the stage of the suit, how do the parties bring their suit before the court? So the plaintiff comes to the court, and obviously he hands over a certain document to the judge. And then in response to that, the defendant will offer his defense by offering a document to the court. Now, this document that is offered by the plaintiff is called the plaint. And the document that is offered by the defendant in response is called the written statement. So we have two documents, the plaint, the submission that is given by the plaintiff, and the written statement, the submission that is given by the defendant, which are collectively known as pleadings, which means pleadings include both the plaint and the written statement. And you can see this in Order 6, Rule 1 of the CPC. Let me tell you as to how you see these orders and rules and sections in the CPC. So if you browse through the bare act of the Code of Civil Procedure, you can see that it begins with a certain number of sections, starting with section number 1, section number 2, and this goes on until section number 158. So you have 158 sections in the Code of Civil Procedure. Now, the Act does not end at these 158 sections. You find that at the end of the 158 sections, you have a schedule, the first schedule, which has something called Order 1. And then you can find that within each order there are many rules, and you have 51 such orders, and within each order you have certain number of rules. So for example, if I want to talk about this provision here, I would call this Order 1, because you can see the order here, and I will call this Order 1 Rule 2. So for example, if I'm to refer to this, I would call this Order 51 Rule 1. So the order that deals with pleadings is Order 6. So Order 6 talks about pleadings, and you can see here that it contains 18 rules. So if I want to say talk about the amendment of pleadings, for example, the amendment of pleadings is contained in Order 6, Rule 17. So we now understand as to how we have to read these orders. So we just saw that Order 6 contains pleadings, Order 7 talks about the plaint, and then you have Order 8 that talks about the written statement and also about set-off and counterclaim, which we shall see in a bit. So when you want to see any of the rules relating to pleadings, you know that you have to refer to Order 6, 7 and 8. If you see all of these rules, you will understand pleading really well. So we were looking at Order 6, Rule 1, which tells you that the pleading shall mean the plaint or written statement. which means that Order 6, which deals with pleadings, deals with both the plaint and the written statement. So Order 6, which deals with pleadings generally, relates to both the plaint as well as the written statement, which I shall now call WS. Order 7 deals specifically with the plaint, and Order 8 pertains to the written statement. What you need to understand is that these are pleadings, and pleadings are what you write and give to the court to let the court know as to what the dispute is. And there are some rules and a certain format that needs to be followed, and we will study these. Let's go and look at the rules one by one to understand as to how pleadings must be correctly drafted. The most important rule relating to pleadings is that the pleadings must state facts, but they must not state the law or evidence. Now, if you want to know as to what the definition of fact is, what is evidence and what is law, well, you're welcome. You can go and have a look at Section 3 of the Indian Evidence Act. It talks about what facts are. If you want to know what law means, you can go and have a look at Article 13 of the Constitution. It tells you as to what law is. But for the time being, let us understand that we are supposed to state the facts and not the law or the evidence in the pleadings. So you can see this point in Order 6, Rule 2. So we saw that there is an Order 6 which deals with pleadings generally. We've already seen what the Rule 1 was. Here you have Order 6, Rule 2. Now it tells you that the pleadings must state material facts and not the evidence. So it says that every pleading shall contain in a concise form the material facts but not the evidence. The sub-rule 2. So now you can see that you have Order 6, Rule 2, and then there's sub-rule 1, sub-rule 2 and sub-rule 3. So the way you denote this is by saying Order 6, Rule 2, sub-rule 2, right? So you can see that sub-rule 2 tells you that every pleading shall, when necessary, be divided into paragraphs. So you have your pleading paragraph wise, and they are to be numbered consecutively. So you number them as 1, 2, 3, 4 and so on. And each allegation should be contained in a separate paragraph. So each thing that you say, so for example, you say that he took my money on so and so date, then he refused to return it on this date and so on. They should ideally be in separate paragraphs. And then it says that the dates, sums and numbers shall be expressed in figures as well as in words. So let us say someone had taken 2,000 rupees of yours. You would say 2,000. This is in words, and you'd also write it in figures. Let's go ahead. Perhaps you might wonder, why can the law not be included in the pleadings? Well, the law need not be stated in the pleadings because the court is presumed to know what the law is. This is Section 57 of the Indian Evidence Act, which says that the court must take judicial notice of several things, and the first amongst those are the laws that are in force in India. So all the laws that are in force in India are already presumed to be known by the court. So you do not need to state them in your pleadings. So let us take a brief example of what should be stated in the pleadings and what should not. Let us say you have a problem, and your problem is that maybe your employer did not pay you your salary. Now, when you are drafting your pleading, you do not need to state the law or the evidence, you have to state the facts. So you say, for example, that my name is so-and-so, and I'm employed as so-and-so at this company since so-and-so. Then you go ahead and say that my salary is this much, and you say that I have not been paid my salary for the months of this, and so on. You state fact after fact. But what you're not supposed to do is to talk like a lawyer giving his arguments, citing the law, and you can't say here that it's my legal right and there was a valid contract with due consideration and here's the document for you to see. You don't present evidence and you don't talk about the law. You basically state your problem through the facts. So I hope now you understand what you understand by the facts. You might also have seen that you are required to state the material facts. Not all the facts, but only the material facts, which means you don't talk about irrelevant things that don't contribute to your case or don't showcase your cause of action. You have to talk only about material facts. Apart from the law which is presumed, there are also certain facts which are presumed by the court. An example of this is in section 114 of the Indian Evidence Act. You can go ahead and have a look at this provision if you want to. It contains numerous illustrations starting with A, B, and so on. It would help you to have a look at this section. So there are several facts that again the court presumes. And if the fact is presumed, you do not need to include such facts in the pleadings. We'd seen in Order 6 Rule 2 that it is desirable for the pleadings to be concise, which means it should not include too many details. So even if there are material details, you want to keep them concise. For example, you can have a look at Order 6 Rule 9, which tells you that let us say there's a certain document, the contents of which are material, right? Still, it is sufficient to just state the effect of that document rather than actually setting out the entire document. So for example, let us say you want to claim that you have now been bequeathed certain property through a will. Okay, so let us say this was the will of maybe a certain relative because of which you have now got money. There's no need in the pleading to write down the entire will. If you can just state the effect of the will that, well, as a result of the will dated so and so, I have been bequeathed this much money. You can just state that I have been bequeathed rupees, whatever. Or, for example, let's say you believe there's a contract between, say, two parties, one the plaintiff and maybe the defendant. There's no need to give the entire details of the contract. You can just say that as a result of the contract, you were supposed to be paid so and so. Okay, so you just state the effect of the document rather than its contents. So we'd seen that the general rule was that pleadings must talk about the facts and not about the law. However, there are some exceptions that I'd like to discuss with you. These are cases in which the law can be stated in the pleadings. So we'd seen that there's a presumption that the courts know Indian law, but there's no such presumption for foreign law. Therefore, if you're relying upon any foreign law, this may be included in the pleadings. There are also some other aspects of law that can be included into the pleadings. These relate to the law of limitation, the rules of res judicata, res sub judice, and estoppel. Let me very briefly take you through them. So these are basically some technical points that can serve as bars on the progression of the suit. So it helps you decide immediately based on some technical criteria. So you know that the law of limitation is basically learned from the Limitation Act of 1963. And if a suit is filed, which means the plaintiff files his plaint later than a certain period, which is called the period of limitation, then he does not have the remedy. The remedy is barred by the law of limitation. So the defendant can say that, look, he writes in his pleadings, which is the written statement, he can make a mention of the law of limitation. He can say that, well, it has been that the plaint has been filed after the law of limitation, and therefore he can talk about this in the pleading. Likewise, sometimes a suit may be barred by res judicata or res sub judice. Now, res judicata is something that you find in section 11 of the CPC. Res sub judice is something you find in section 10 of the CPC. These basically are bars. Res judicata is because a matter between the same parties has been previously decided by the court, and therefore you don't want to have this happening again. Res sub judice is where you have a similar matter between the parties that is presently being tried by another court. So again, these are things that can be stated in the pleadings because they allow for a bar on the progression of the civil process. Likewise, even facts that show that a person is estopped from saying something. Now, estoppel is something that you find in section 115 to 118, 117 of the Indian Evidence Act. And estoppel is basically a bar that prevents a person from stating something contrary to what one has said previously. So these are some exceptions that, despite being points of law, can be included in the pleadings. To gain a holistic understanding of what the rules of pleadings are, you are indeed required to look at Order 6 completely, which has 18 rules. And if you go through all of these rules, you will get a good grasp on what the rules relating to pleadings are. But as a summary, let me tell you a couple of fundamental rules relating to pleadings. The first point, as we saw, is that it should not contain the law. It should not contain evidence. You should speak only about the facts. Those facts should be material facts, and it all should be presented in a manner that is concise, precise, and clear. Now, I recommend for you to study all of the 18 rules that relate to pleadings under Order 6. But before we proceed to Order 7, I'd just like to talk about two more provisions, and these are Order 6, Rule 16, and Rule 17. Let us say you have drafted a pleading and that pleading does not comply with the rules that are stipulated. In such a scenario, what could happen? Let's first look at Order 6, Rule 16, which talks about striking out of pleadings. So let us say it is found that the pleadings contain things which are unnecessary, scandalous, frivolous, or vexatious, or it delays the fair trial or embarrasses the process of fair trial, or otherwise abuses the process of the court, then the court may order the pleadings to be struck out. So this is done by the court because the pleadings are not correct. The other thing is that maybe you've made a mistake in the pleading and you may want to bring some changes. So in such a scenario, the court may allow a party to go ahead and change their pleadings. So you can alter or amend your pleadings, and that is allowed and that is provided for under Order 6, Rule 17. Now you have a pretty fair idea of what Order 6 is. Let us proceed to Order 7, talk about the plaint. And like I said, since plaint is also a pleading, you learn more about pleadings even as we study Order 7 and 8. So we've seen that we have Order 6 that deals with pleadings, and Order 7 that deals with the plaint, and Order 8 that deals with the written statement. Now it's important for you to know that it is through the plaint that the suit is instituted, right? So the suit is instituted by the presentation of the plaint, and this is something you can see in section 26 of the CPC and also through Order 4, Rule 1. The suit is instituted by the presentation of the plaint. Now you should understand that the plaintiff is the person who approaches the court, right? So like I said, you have the court. Okay, let's think of this as the court. So now the person who first approaches the court and says that give me some remedy, the person who approaches the court is the plaintiff, and the plaintiff presents the plaint, and upon the presentation of the plaint, the suit is instituted. Now there's a pretty elaborate procedure that happens. You can have things like, say, a summons are sent and all of that, and then you get the other party, the defendant. You also get the defendant before the court. Okay, and like we just saw, that in response to what has been averred by the plaintiff, the defendant submits his written statement. So what we've seen is that the responsibility to present the pleadings is first on the plaintiff, and then in response the defendant does that. Now where does this burden, where does this responsibility come from? Why does the plaintiff have to first present his pleading? You can perhaps find this in section 101 of the Indian Evidence Act, which talks about the burden of proof. You'd see that the burden of proof lies on the plaintiff, because the plaintiff is the person who desires the court to give a judgment as to a legal right, right? So the plaintiff wants the court to give a judgment in his favor, and since he is the person going to the court, the burden of proof lies on him, and thus you can understand that it is first the plaint that is presented, and it is only in response later that the written statement has to be given. So before we even look at the rules under Order 7, for the sake of your understanding, I'd like you to picture the plaint as having four parts. I mean, there's no such actual formal division, but these four parts are for the sake of your own understanding and clarity. You can think of the first part as the part that lets you know as to what the court is. So it tells you that, for example, in the court of the district judge so and so place, and then it tells you suit number so and so of 2023, and then it discloses the names and the details of the litigating parties. This you can understand as the first part. Next, you have the part where the material facts are basically stated, which disclose the cause of action. You can kind of think of this as the main part of the plaint, wherein you disclose the cause of action, right? As to what the circumstances were that make you feel that you are entitled to a legal right that the court can adjudge. In this, you would understand that there are some points that you speak from what has happened to you. So, for example, you say that the defendant owes me this much on this thing. We had entered into a contract on so and so date. He refused to give me on so and so. There are also some other points within this which relate to the payment of the court fee, whether there are any claims that are made as to the limitation period, etc. So there are some points here that are of some legal nature as well, but collectively these establish the cause of action. Now, once that is done, you go ahead and present your prayer to the court. So in the third part, you are seeking the relief. You state what you want from the court. So you say that you humbly pray that the court may give you whatever, like give me back my money on this and that. And you also add in this that the court may grant any further relief or any other relief that the court finds suitable. This is the third part. And then you have the final part, which is called the verification. There's a slight typo in here. Let me just strike this part off. Okay. So you can see here in the verification, basically you verify that what has been said in the plaint is true. So you saw that I just struck off advocate from here. That is because in the relief you will have the signatures of both the plaintiff and the advocate, but in the verification it's only the plaintiff. So in the verification, the plaintiff verifies that whatever he said is true. Now you can see that there are two parts to this. For the statements that the plaintiff knows, he says that these are true to the best of his knowledge, but there are certain facts which, well, a layman may not know, and you believe your lawyer. So for example, your lawyer tells you that the appropriate court fee here is 2,000 rupees, and therefore you've said here that you have paid 2,000 rupees court fees. Now this is something that you believe to be true based upon the advice of your lawyer, so you write that in here. So this is the main structure, the basic outline of a plaint. To know of this in greater detail, you can go search for this on the internet. You will find various samples, and then you find that there are various facts. This is the main outline. Let's look at a few provisions of Order 7 to get this in greater detail, but this should basically give you the template that you should work on. Templates are also easily available in books and on the internet. You can go ahead and look at those for getting this in greater detail. So we now advance to Order 7, which gives you details about the plaint. Let us begin with the first rule, which talks about the particulars that are to be contained in the plaint. Now, to understand this provision, it's important for you to pause this video and try reading this by yourself, either from here or from the Bare Act. So you can see here that it tells you what should be contained, what kind of details are required to be contained in the plaint. So you can see that it should contain the name of the court. So you say in the court of the senior civil judge so and so, or in the court of the district judge so and so. Then the name, description, place of residence of plaintiff. You can go have a look at all of this. You can understand what this is. So for example, if you see here, it says where the person is a minor or of unsound mind. In such a case, you have to say that that this person is being represented through so and so, who is the next of kin. You have to show that the court has jurisdiction, the relief that is sought. Here this talks about a set off. I'll talk about this in a moment when we proceed to Order 8 and so on. So read this carefully. It tells you as to what the contents of the plaint should be. Like with Order 6, I would recommend for you to look at all the rules of Order 7. Let's quickly go through a couple of those now. For example, let's take Rule 2 of Order 7, which says that in a money suit, which is basically a suit where the plaintiff seeks the recovery of money, the plaint shall state the precise amount of money claimed. Right? You can read all of this in greater detail. Likewise, Rule 3 of Order 7 says that when the subject matter is immovable property, let's say a certain building or a house, then the plaint shall contain a description of the property sufficient to identify it. So many times you do this by either demarcating the boundaries or by showing a map or giving the proper address, etc. So you can see more of these provisions that will help you. Let us skim through a few more rules. For example, if you look at Rule 7, it says that the plaint should state specifically the relief which is claimed. We saw the relief as the third part in the plaint. Either simply, or you may seek an alternative where you say that you may grant me anything else. Okay. It also says here that the same rule shall apply to the defendant in his written statement. Very interesting. You have a point in Order 7 that talks about the written statement, although Order 7 technically is only about the plaint. Likewise, you have a rule here, Rule 14, that says that when the plaintiff relies upon a document, he should present that document along with the plaint. Moving ahead, let's look at another rule, Rule 6 of Order 7. So you know that for a suit not to be barred by limitation, it should be filed within the prescribed period of limitation. But there are some occasions in which this may be exempted. So for example, if you look at Section 5 of the Limitation Act, you'd find certain grounds that are listed there which allow for delay to be condoned. So it deals with the condonation of delay. So in case the plaintiff wants to rely on any such grounds, he must specifically state them. That's what Rule 6 tells you. Now we come to the question. I've told you a couple of rules about how the plaint should be, but what if you do not follow the rules that have been laid out? The first thing that can happen is that, let's say you go and you file the plaint in the court that does not have proper jurisdiction. So let us say there was a certain suit that should have been filed with the district judge, with the district court, but you went and filed that in a lower court. Let's say you went and filed that in the court of the civil judge, junior division. In such a case, the plaint would be returned. So that's called the return of the plaint, and then it has to be presented to the court where the actual jurisdiction lies. There's another thing that can happen. Let us say there are certain mistakes in the suit, in the plaint, because of which it would have to be rejected. You can have a look at this. For example, if it does not disclose the cause of action, which means you don't state the grounds for which you have come to the court. Where the relief is undervalued, which means that you have, let's say there was a certain property. Let's say the property in dispute was your house, okay? And you state the value of your house as being only 1,000 rupees. Now, when you state the value of your house as being 1,000 rupees, you pay less court fees. So many times as a malpractice, often the plaintiffs undervalue the property. So if one has done so, and even after the court has told the person to correct that, the court told the plaintiff to correct that, then the plaint could be rejected. So you can see here that there are other grounds which could lead to the rejection of the plaint. I'd urge you to pause the video and read this either from here or from the Bare Act. It would help you to know as to what the grounds of return and rejection of plaint are. So we've seen the rules that tell us as to what should be included in the plaint and as to what should not. Now when this is clear, it's fine, but there are some situations in which you might be in doubt whether a certain fact should be included or whether it should not be included, and you're not sure. In such a scenario, perhaps it's a good idea to actually include that, and I'll talk about the reason in a bit. Now, there's this principle that is called constructive res judicata. Now what this means is that if there was a certain fact that you could or you ought to have stated earlier, but you did not, right? Then the rule of constructive res judicata prevents you from doing that at any later stage, which means that let us say there was a certain claim. Let us say somebody owed you maybe a pen, he also owed you a bottle of ink, and he also owed you some paper. And you were required and you could have stated all of these in your plaint. But you only spoke about the ink and forgot the rest. So the rule of constructive res judicata prevents you from being able to state these later. You can also in some ways think of this as the rule of estoppel, but it's more appropriately called the rule of constructive res judicata. So you can see this in two places in the CPC. The first is in explanation 4 to section 11 of the CPC, and you also find that in rule 2 of order 2. So order 2 deals with the frame of suits, and in that you find in the second rule, it tells you that if there is a certain claim that the plaintiff does not state in the plaint initially, then he is prevented from stating that later on. So coming back to the question, when in doubt, should you state it or not state it? You should state it, because if you don't say it now, then perhaps you cannot say it later, right? Let's go ahead. You might remember that we discussed that there are 4 parts that you can think of in the plaint, and the 4th part was that of the verification. Order 6, Rule 15. So this is Order 6, Rule 15, talks about the verification of pleadings, which says here that every pleading shall be verified at the foot, at the end of it, by the party. And you can also see from sub-rule 4 here that the pleading shall also furnish an affidavit in support of the verification of the pleadings. So let us now finally once again look at the contents of the plaint. The first part of it consists of mentioning the court, the suit number, and specifying the parties. Next, since this is the plaint, these are the submissions of the plaintiff, and the plaintiff submits the material facts. Remember to also include the points relating to when the cause of action arose. So you must state the date of the cause of action. You must also include in here the point that shows that the court has jurisdiction. You must include the point that shows that you have paid the requisite court fee and that you have filed the suit within the limitation period. Right? So this is the third part. In the fourth part, you present your prayer, the relief that you seek, and you can either seek that singly or in alternative, wherein you can ask for any further relief, and then you have the verification. This is the format of the plaint, and it's good for you to understand this because you'd find that for the most part this is very similar even to the written statement. So you'd find that when we now go to the written statement, the parts 1, so part 1, part 3 and part 4 are in many ways very similar looking to the plaint, and what you'd have in part 2 is that each of these points is tackled by the defendant, and we'll study this now. Let's go and look at the written statement. So as I said, the suit is instituted by the submission of the plaint. So section 26 as well as order 4 tell you that the suit is instituted by the submission or the presentation of the plaint. So now once the plaintiff has presented the plaint, you need to get the defendant into the court. And order 5 talks about the issue and service of summons. So as you can see from here, once the suit has been instituted, and how does that happen? It happens by the presentation of the plaint. Summons may be issued to the defendant, and he has to then file his written statement of defense, if any, within 30 days. Okay. And then let's see a similar provision in order 8 as well. So we saw that order 8 deals with written statements, and you can see that rule 1 says that the defendant shall, within 30 days of the summons, present a written statement. And you can see from the proviso here, when it says provided, this is the proviso, it lets you know that this can be extended to a period of not more than 90 days. So now you know that a plaint in its main body has certain facts that are numbered as you can see here as 1, 2, 3, 4. So you have these points with you. Now, for any point, you might appreciate that a certain fact that is stated here, because you have facts in here, a fact could either be admitted, which means that you say that yes, it is true, or you may deny it, or there might be a partial admission or a partial denial. That's what you can do, right? And in most cases, there is a denial because very rarely does the defendant admit what the plaintiff is saying. So in most cases there is a denial. So for example, if the plaintiff says that the defendant took 500 rupees from me, very rarely does the defendant admit that yes I took. He wants to say no I did not. So this is a denial, right? So let me ask you a question. Suppose in the written statement the defendant simply just uses one line and he says that look, the defendant denies the truth of the entire plaint. Is this a valid way of framing the written statement? What do you think? The answer is no. If you look at Rule 3, Order 8, Rule 3, it tells you that the denial has to be specific. As you see, it says here that the written statement, it will not be sufficient if you deny generally. The denial has to specifically deal with each allegation of fact, which means that when you look at the plaint and it contains 1, 2, 3, you are to specifically address each one of these in the written statement individually. And what happens if you don't address any one of these? Let's take, for example, maybe the second fact says that, let's say that the first fact is that there was a contract, okay, between the plaintiff and the defendant. This is what is given in the in the plaint. Now suppose this is not denied. What is the effect of that? The effect of that can be seen in Rule 5 of Order 8. It says that for every allegation in the plaint, if it is not specifically denied, it will be taken to be admitted, which means that if you do not deny something, it is treated as an admission. So you should understand this, that if not denied, it is deemed to be admitted. And when something is deemed to be admitted, the court will not look at any evidence or arguments regarding that fact. So this is an important principle that you see in section 58 of the Indian Evidence Act, which broadly tells you that any fact which is admitted need not be proved. So this is the importance of specifically denying each point in the written statement. Let's look at this more closely. Let's say the plaint contains a certain statement here. Then it has a second fact, it has a third fact, and it has a fourth fact. So we saw that the written statement should specifically deny each. So suppose he denies this by says that paragraph 1 is denied. Then for the second one he says para 2 denied. Then for the third one he says denied, fourth denied, and so on. Is it alright for the denial to be made simply with one word, that no, I do not admit, it is denied, not admit, denied? Is that sufficient? The answer to this also is no. I want to point out to you that to simply say no or to simply say not admitted or to simply say that it is denied is a form of denial that is called evasive denial. And this is not correct. And for that you can look at Order 8, Rule 4, where it says that he must not deny evasively. Let's have a look at this. So it says that where a defendant denies allegation of fact, he must not do so evasively, but actually answer the point of substance. What you could do right now is to pause the video and read this example. So you can see here that you actually have an example from here going up to this. You can pause the video and try understanding this example by yourself. So here's my example for you. Let's say the third statement or the third paragraph in the plaint contains this fact. It says that the defendant received rupees 5,400 from the plaintiff on 4th February 2013. Now in the written statement, you can't simply just say no, or you can't say that para 3 is untrue. You can't say that. What you have to really say is something that's pretty detailed. So you have to say in the written statement, if you want to deny this, that the defendant did not receive rupees 5,400 or any other amount, because you could be someone that says, hey, I did not receive 5,400, but I received 5,399. So you say, I did not receive 5,400 or any other amount from the plaintiff on the 4th of Feb 2013 or any other day. So when you respond to it like this, and therefore you say that, then you go on to say that therefore para number 3 is not admitted, and you say it is denied. Now this is the right way of denying a statement or an averment in the plaint. So we've understood that the written statement has to be a para-wise reply to what is stated in the plaint. So let us take, for example, for the first point, the written statement. The defendant says in the written statement that the first fact is correct, and he says it is, therefore it is admitted. That's what he says. For the second one, maybe he says that it is not correct, and therefore it is not admitted, and therefore denied. And like I said, when there's a denial, you have to explain it. It cannot be an evasive denial, and so on. So either there's going to be an admission or there's going to be a denial. In such a case, we can find that there are certain facts that have been alleged by the plaintiff and which have been denied by the defendant. Right? These are the points of dispute. These are the facts in issue, and it is on the basis of these that the issues are framed. Right? So if you have a look at order 14 of the Act, you can see the framing of issues. The issues are identified and framed on the basis of the facts that are found to be disputed in the pleadings. So I hope you can now understand as to why it is so important to draft these pleadings correctly. So in the written statement, of course, he must first respond to what has been stated in the plaint, but in addition to that, he can also make some additional pleas. Okay, and these also have to be marked. Let's say the first 8 points were in response, then you can go ahead and mark these as 9, 10, 11, and so on. I'd also now like to talk about 2 points about the counterclaim and set off, because as you can see, the title of order 8 contained not just written statements but also counterclaim and set off. Let's look at the relevant provisions and understand as to what these mean. So let's talk about set off and counterclaim. Set off, as you can see, is in rule 6 here, and the counterclaim is something that you see in rule 6a here. Now there's a slight difference. No, there's a significant difference between set off and counterclaim. The first point that you should know is that a set off is something that you have only in what are called money suits, whereas a counterclaim is much broader than that. And a money suit basically is a suit for the recovery of money, as you can see here, a suit for the recovery of money. Let me explain this to you in a simple way. Let us say that in the plaint, the plaintiff says that the defendant owes him rupees 500. Okay, 500 rupees. Now, what the written statement, the defendant says that, look, I owed him 500 rupees, but he owes me another 300 rupees. And therefore he says that I actually owe him 500 minus 300. Actually, I owe him 200 rupees. So this is a set off, whereby you're setting off the mutual claims, and then you say that, you know what, I only have 200. So this is a set off. Now what is a counterclaim? A counterclaim by the defendant is that, look, the defendant says that, see, just as the plaintiff is saying that he has a cause of action against the defendant, in a counterclaim, the defendant says that there's a cause of action against the plaintiff. So you see here, let me highlight this for you. He says in respect of a cause of action accruing to the defendant against the plaintiff. So he talks of his cause of action. And in such a scenario, It's like the defendant behaves like the plaintiff. So here you talk about the counter. So it's important for you to know set off and counterclaim in addition to the defense that you have in the written statement. So of course, even the counterclaim and the set off are to be included into the written statement. So we'd seen that once a plaint has been submitted and then the defendant is called upon by means of the summons to present the written statement in the proper format within a certain period. But what if the written statement is not duly presented? What happens? The effect of that can be seen in Order 8, Rule 10. So when the written statement is not presented within the permitted time, right? Then in such a case, the court shall pronounce the judgment against him or make an order that it thinks fit. So if you do not present your written statement, the court will proceed anyway. It will not wait for you indefinitely, and therefore presenting the written statement is very important. So over the course of the last 45 minutes, I hope we have been in a position to acquaint ourselves with the rules relating to plaint and WS. I said that there are four parts of the plaint. Let's have a look at them one final time. Now you have the facts in here. In the prayer of the plaint, of course, the plaintiff wants that the suit be decreed in his favor, so that he prays that it be decreed. And generally, along with this, you also ask for costs. If you want to study what costs mean, you can have a look at section 35. But costs basically refer to the costs that were incurred in the litigation process. And then, of course, you have the verification. Like I said, you should pay careful heed to the fact that in the prayer, you have both the plaintiff and the advocate, apart from the date and place, whereas in the verification, it's only the plaintiff. In response to this in the WS, you can see that this part is very similar because it is in the same court. When you look at the second part of it, now the facts here are either admitted as being correct or they are denied. And like I said, the denial should not be evasive. You also deny points like there's no cause of action, no jurisdiction, and all of these. In addition, if you want, you can also have the additional pleas here. The prayer of the defendant through the written statement, obviously, is the contrary of what the plaint says. So he generally prays that the suit be dismissed and also asks for costs. Again, here you can see that this should have been the defendant. Sorry, apologize for the typo. This is the defendant. Okay, and so it says here, you can see here that the signature in this case is of both the defendant and the advocate, whereas here it's only the defendant. So with this, I think we've given ourselves a pretty fair idea of what pleadings are with respect to orders 6, 7, and 8 of the CPC. Thank you very much.